It's not uncommon in the context of child custody and visitation cases for the custodial parent wanting to relocate. And when we say custodial, we're really talking about, for purposes of this video, the parent that has primary residency. Sometimes the custodial parent will want to relocate to a new city, a different county, or possibly a new state. And the problem becomes when the non-custodial parent, that person's visitation rights, time with the child or children, becomes impacted by the move. So for custodial parents, before they can relocate to a new area, they, more often than not, depending on how far they're going to be moving, have to seek judicial permission to relocate. And for the non-custodial parent, there are times, and we've had this happen in our firm, where we actually have to file an order to show cause. Basically, we're filing a motion with the court saying, Judge, the custodial parent's getting ready to move, I have visitation rights, we want you to order that person to stay in this area until they either get judicial permission or they don't. And that's called, again, an order to show cause. So when we have these sort of cases, clients always ask us, what is a judge going to be looking at? And there's two things, but they're really interrelated. It's always going to be what is in the best interest of the child or children. But there's also the pinnacle case in New York of Tropia versus Tropia. That was decided by the Court of Appeals, which is the highest court in our state. In that decision, the Court of Appeals has identified various factors that family court, where you'd be filing these motions, has identified various factors that can be considered and that are relevant to the best interest of the child analysis. The first factor that the Tropia court identified was the impact of the move on the relationship with the child. What we're really looking at there is you got to look at the visitation schedule. If you have a visitation schedule where the non-custodial parent has every other week visitation, so it's a week on, week off, obviously a relocation that's a significant distance away is going to severely impact the relationship between that parent and the child. If you have a situation where the non-custodial parent has every other weekend visitation, the impact on the contact with or between the child and the parent will not be as crucial. The other thing the court is going to look at, and this is another thing that the Court of Appeals has identified, is what's the reason that the custodial parent wants to move? And if it's a good reason, it's obviously going to weigh in favor of a relocation. If it's a bad reason, it's not going to weigh in favor. For example, a good reason could be, Judge, I lost my job in this area. We obviously need money to live, and so I can support my child. If I were to move 2 hours away, I'll be making a significant amount of money and to be able to provide a good life for my child. That'd be a good reason. A bad reason. My partner, Tom Jackson, he loves to fish. If he wanted to move from the state of New York down to the state of Florida so he could fish year-round, that'd be a horrible reason, and that probably would not help his case. The other thing the courts are going to look at is what benefits will there be for the child, or what harm will there be for the child if there is a move. Things that the courts will be looking at and under that factor will be maybe the quality of the education. How's a school district where the child is, and how's a school district where the parent is proposing to relocate. They might be looking at extracurricular activities. You have a child that's a star basketball player where they're currently living, could get a scholarship, but where they would be relocating to wouldn't have those same opportunities. That could be a factor. And they're going to be looking also at the nature of the child's relationships with peers. You have a child that's 14, 15, has a ton of friends locally and close to those friends and doesn't want to give up those relationships. That's obviously going to weigh against a relocation. Economic necessity will also be a very important factor, and we talked about that a minute ago. The court's going to say, all right, if you can't make any money where you're living now, but you can make substantially more in a different location, that's a factor in favor. But, if you have a parent that's making $75,000 where they currently live and where they want to move, they would only get an increase in pay of $5,000. that's not going to be really deemed as an economic necessity. Health-related concerns is another factor that's been identified by the court. We don't see this come up too much, but it could. You have a child or children that have very specific, unique health-related problems that can't be treated locally, but can be treated 2 or 3 hours away. That's a factor that can weigh in favor of a relocation. The court also looks at the demands of a remarriage. It's not uncommon for parents that split up, to become remarried, and the courts will look at the nature of those relationships, the stability, what advantages or what benefits does the child get from that second marriage. The other thing the courts will look at is if the feasibility and benefit of a change in custody. And this is one of the factors that the Court of Appeals identified, that if the parent wants to move away and it's going to be a significant distance, would it be in the best interest of the child to change custody from that parent to the parent that lives locally? Another factor the court identified is the feasibility of a parallel move. Quite frankly, that's usually not going to come up where you're going to be asking, the non-custodial parent to move and follow basically the custodial parent. And the ninth factor the Court of Appeals has identified is the good faith that the custodial parent is acting in for the move, and the good faith of the parent opposing the move. You might have a situation where a parent wants to move, and again, this is an extreme example, but a parent wants to relocate away 3 hours just so that the non-custodial parent won't have as much time with the children. Obviously, that's going to weigh against a relocation. The courts will also, and this is common sense, so the court will also look at the sort of attachment that the child or children have with the non-custodial and the custodial parent. That's going to be a very important factor, the nature of the relationship between the two parties. One thing the court will take into consideration is if it grants the move, can a new visitation schedule be structured for the non-custodial parent that will keep constant and significant contact with the non-custodial parent. So they're basically looking to see whether or not they can devise a schedule that will create meaningful contact. Again, if you have a situation where it's a week on, week off time sharing arrangement, and the one parent wants to move 3 hours away, there really isn't any sort of revised visitation schedule that can maintain that level of contact. Another factor, and again, it's just common sense, what's the quality of life going to be? Is the quality of life going to improve if the child relocates, or will it be worse, or will it be the same? An important factor that the courts will look at is the nature of the relationship between the parties. Do they have a hostile relationship with one another? Will the relocation add to that hostile relationship, or will denial of the relocation fuel the fire more, so to speak? Another thing, again, it's all common sense, because again, it's all about best interest of the child. The one factor the court will look at is let's see what we have for family members. If you have a child that lives in Broome County and they have 2 sets of grandparents, they have 4 sets of aunt and uncles, they have 10 cousins, and the custodial parent wants to move to Ohio where there is no extended family, and this child is very close and spends a lot of meaningful time with the relatives in Broome County, that's going to be a huge factor the court will consider in deciding whether or not to grant the relocation. And then there's always the catch-all provision where the court can consider any circumstance it wants which it deems relevant to the issue. But again, the issue is always the best interest of the child. And not surprisingly, one factor that will be taken into consideration, and depending on the age of the child, it can be a very weighty factor, is what does a child or children want to do?